Hello, and thank you for listening to this podcast. My name is Karen Killaley. I am a partner and head of the employment team at Maples and Calder, Ireland, the Maples Group's law firm in Dublin. Before we dive into today's subject, the usual housekeeping to cover off. If you are listening in from your usual podcast app, you'll find any resource documents and speaker information in the description. If you've clicked on the media player link sent to you by email, you can find this information in the notes section. Please note, as always, this podcast contains a general overview of pay transparency from an Irish employment law perspective to help illustrate and discuss some issues that may be of interest to employers in Ireland. It does not constitute legal advice, and if you do have a specific situation or question, please do contact us. So I'm joined today by my colleagues, Kieran Lungig and Christina Connaughton, who are both associates on the employment team here at Maples in Dublin. And in this podcast, we are taking a close look at the EU Pay Transparency Directive and recent developments relevant to employers in Ireland, and in particular, an update on implementation. So, the long awaited date of 7th June is very close, and we are still awaiting the Irish transposing legislation. So, for the purposes of today's podcast, we will walk through the directive and we will tell you where things stand regarding transposition and implementation in Ireland. It is not yet implemented. We will also take a closer look at a very helpful tool, which is the recently published EU-wide guidelines on gender neutral job evaluation and classification. So a bit of a mouthful, but it's actually a very, very helpful toolkit for employers in Ireland who are grappling with the thorny issue of constructing job categories. So as always, we'll try to provide some practical tips for employers in Ireland, and do take a look at our previous client update on this topic, which is in the show notes. Okay, so we are going to kick off. Ciara, I'm going to turn to you first. Let's have a brief recap on the directive itself. So, do you want to just give us an overview of what the Pay Transparency Directive is about and what it is trying to achieve?
Yes, absolutely. So the EU Pay Transparency Directive was adopted in May 2023. And as you've mentioned, the directive was due to be transposed into Irish law by 7th of June this year. Unfortunately, as you've said, we will miss that transposition deadline. Looking at the directive itself, at its core, the directive is about strengthening the application of the principle of equal pay for equal work or work of equal value between men and women through pay transparency and enforcement mechanisms. To put this in context, the principle of equal pay has been enshrined in EU law for decades, and this is not a new concept. Even on a global scale, the International Labour Organization first recognised the principle of equal remuneration for work of equal value back in 1919, so not a new concept. The directive does, however, give that principle real teeth by introducing specific transparency obligations and enhanced enforcement tools. The reality is that despite the principle being well established, the gender pay gap has persisted across the EU. This directive is designed to tackle that by making pay practices more visible and giving workers and their representatives the tools to challenge inequalities. The directive has very broad scope. It applies to all employees under various forms of employment relationships, including full-time, part-time, fixed term, agency workers, workers in management positions, and even extends to trainees, apprentices, and platform workers. It also applies to job applicants in relation to the pre-employment transparency obligations, which we will talk about in just a moment.
That's great. Thanks, Ciara. I mean, it goes without saying a really, really wide scope, and I would say probably one of the most significant developments in Irish employment law in recent years. And I suppose just to add, one of the key developments, I suppose, and one of the most likely developments to actually be implemented in practice relates to recruitment and recruitment practices. So the directive introduces pre-employment pay transparency obligations, as you've touched on. And as we know, employers will be required to provide candidates with information on pay levels or pay ranges in advance of employment. We know there will be a prohibition on asking candidates about their pay history and so forth. This is quite a significant shift from an Irish law perspective. These types of obligations already do operate in a number of other jurisdictions, including in a couple of states in the US, but not here. Many employers here would regard pay information as, almost commercially sensitive, confidential information, which they would not want in the hands of their competitors. So it is a real sort of cultural shift here. But having said that, we are certainly fielding lots and lots of questions about this in the market, with employers asking, how precisely is this going to play out? Where do we have to publish this information? Do we have to publish it to the world at large? Can we give it perhaps closer to the offer stage, or how is this going to work? So again, we are waiting for the implementing legislation in order to determine how this is going to work in practice. So having said that, Ciara, would you just take us through some of the other key points to note?
Yes, no problem. The directive also establishes information rights for employees regarding pay setting information and pay progression information. So, under the directive, workers have a right to request and receive in writing information on their individual pay level and on the average pay levels broken down by gender for categories of workers performing the same work or work of equal value. And we'll touch on that a little bit more in just a moment, what that means in practice. The employer must provide this information within a reasonable time frame and no later than 2 months from the date of request. Workers can make this request either individually or where there's a fear of adverse treatment through their worker representatives or an equality body. Importantly, an employer must inform workers annually about this right and the steps required to exercise it. So there's actually an active obligation on employers to keep workers informed of their entitlements under the directive. There are also limitations on pay secrecy included in the directive. So, blanket contractual terms that prevent workers from disclosing their pay or seeking information about pay will not be permissible, as employees must be permitted to disclose information if they're seeking to take an equal pay claim. And then finally, the directive includes enhanced gender pay gap reporting obligations, where an employer's gender pay gap reporting reveals a difference in average pay levels between women and men of at least 5% in any category of workers that cannot be justified on the basis of objective or gender neutral criteria. Employers will be required to carry out a joint pay assessment in cooperation with workers' representatives. And I know you're going to dive into that detail a little bit further in just a moment, Karen.
Yes, exactly. Thanks, Ciara. And I suppose just to almost summarize, really what we're saying is, at its core, the directive really requires employers in Ireland to make the criteria which are used to determine pay grades, and pay progression easily accessible to employees from now on. And the criteria which is used to determine and calculate reward must be objective, and it must be gender neutral. So, in addition to having a coherent pay structure, that pay structure must be transparent, and the reward criteria must not include gender directly or indirectly as a criterion for reward. So just one other piece before I turn to you, Christina, and we talk about where this is at and when it's going to come into force, and a little bit more around that. Just one piece that I wanted to touch on, because we have been fielding, I think, a lot of questions about this, certainly from employers in Ireland, and that relates to the role of employee representatives. So there is certainly an emerging and significant role for employee representatives under the Pay Transparency Directive, largely in relation to interrogating and evaluating an employer's compliance with both their equal pay obligations, their existing equal pay obligations, and their new pay transparency obligations. So I suppose just by way of brief update, the position in relation to the role of employee representatives absolutely remains to be clarified by the Irish implementing legislation. So, in other words, we can't really say with any certainty to what extent, for example, employers in Ireland, so private employers who are, for example, non-unionized, to what extent they would now need to have a standing employee representative body. Does that now need to be maintained in businesses where perhaps there are no such existing formal or permanent employee representative body. So these are all questions that employers are sort of grappling with, and we just don't have the answers at the moment. Hopefully that will be clarified in the legislation. So probably also worth noting that in Ireland, existing legislation provides for relatively limited situations in which employers and employees are required to inform and consult with one another using an employee representative body. So, for example, that does happen and it's on a statutory footing in relation to collective redundancy situations, in relation to obviously a classic sort of TUPE situation, a transfer of undertaking situation. And then in relation to certain health and safety matters, information and consultation obligations arise rather. But largely in Ireland, we operate, I suppose, what you might describe in a voluntarist trade union and industrial relations setting. We have relatively limited situations where there is a clear obligation to consult with the view to reaching agreement with employee representatives. So, having said all of that, it is clear that the role of employee reps will come into sharper focus. In the Pay Transparency Directive, there is a much clearer voice for employee reps under the directive. And I suppose if I was to summarize maybe the 3 or 4 areas where we're going to see that. I think the first one is in relation to the making of and the receipt of responses to individual pay transparency requests. So not only as it relates to individuals, but as it relates to categories of workers. So Ciara touched on that a few moments ago. That's one of the key changes under the directive. So these requests and the responses to those requests may be channeled through employee representatives. We don't know what that's going to look like, but the directive contemplates it. Another area where employee representatives will have a role is where disclosure of pay data by an employer would reveal an identifiable employee's pay. If that happens, then access to that information could be disclosed to employee representatives, or in fact to a labour inspectorate, which in Ireland is the WRC, or to an equality body such as IREC, for example, rather than necessarily empowering the employer to refuse to respond to that request. So in other words, if there's sort of a privacy concern about that information, it may wind up going to employee reps rather than to the employee itself or another third party. Again, this needs to be clarified under the implementing legislation. A third area where employee reps will have a role under the directive is in relation to interrogating and challenging and advising on the construction of job categories. So the categories of workers for the purposes of gender pay gap reporting and for the provision of pay transparency information in response to requests. And then one other sort of area where they will have a role that I call out, there are others, but the other piece that is important to bear in mind is if an employer in Ireland reports a gender pay gap of 5% or more, then employee representatives can trigger a joint pay assessment. And that in practice will envisage a quite material supervisory stroke partnership role for employee representatives in assessing the reasons for the gender pay gap that has been reported, reviewing the methodology used by the employer, potentially interrogating, disagreeing with that, and then agreeing and really supervising the corrective measures that are put in place, that are agreed and put in place to address the gender pay gap. So, in summary, quite an enhanced role for employee reps under the directive. We are not sure how that's going to work in practice, but the directive certainly envisages a more vivid role for employees in this pay transparency journey. And speaking of pay transparency journey, Christina, where do things stand? Having said all of that, where do things now stand in terms of transposition into Irish law?
Thanks, Karen. So the heads of the Pay Transparency Bill, which will transpose the directive into Irish law, are currently in preparation. And obviously, as we said before, the directive's required to be transposed by the 7th of June 2026. The Department of Children, Disability and Equality, which is responsible for transposing it in Ireland, has indicated that this date won't be met. Instead, implementation is expected to take place on a phased basis, and the department has confirmed that it intends to work with employers, employees, and their representatives to assist with implementation of the directive.
Thanks, Christina. That will be of some comfort to employers, and it's not entirely surprising given the breadth of what needs to be implemented. Is there any indication of what phase might come first for implementation?
Yes, Karen. So the department recently confirmed that in relation to the sections of the Pay Transparency Bill regarding the publication of pay ranges on job postings, that officials are still considering recommendations from last October's pre-legislative scrutiny report, and that other factors have also impacted its work. This provides indication that the pre-employment pay transparency elements of the directive may be prioritised for implementation in Ireland. What we're seeing here mirrors the approach taken with other EU directives that have a broad scope. The transposition tends to come in phases, with the most immediately impactful elements arriving first. Employers shouldn't take the delayed timeline as a reason to delay their own preparations, and the phased approach actually gives employers an opportunity to get ahead of the curve.
Yeah, absolutely. Thanks, Christina. It does. And certainly our experience in the market would be that the vast majority of employers in Ireland whom we work with are quite advanced in their planning and preparation for the implementation of it. But probably also worth noting that absent implementing legislation, and again, this is another question that we're seeing quite a lot in practice, absent the Irish implementing legislation, while it is certainly important to continue with the preparations, there is currently no statutory enforcement mechanism which applies to private employers in the context of the specific new pay transparency obligations. Obviously, existing equal pay obligations under the Equality Acts have their own enforcement mechanism, which remains in full force and effect, but that doesn't apply to the new pay transparency directive obligations that we're talking about here. Okay, so look, we will shift gears again a little bit. There is a development and there is a little bit of clarity, which I think is helpful, and that is the publication of the EU guidelines on gender neutral job evaluation and classification, otherwise known as the toolkit. A copy of it is in our show notes, and we're going to talk about that for a moment. Or Christina, you're going to take us through that. So these guidelines have been published relatively recently. Do you want to talk to us a little bit more about their value?
Of course. So the guidelines are essentially a step-by-step toolkit to help employers carry out a gender-neutral job evaluation and classification. And we've included a copy of it, like I said, in the show notes. The toolkit is significant because under the directive, the value of work must be assessed on the basis of objective and gender-neutral criteria, specifically skills, responsibilities, effort, and working conditions. Gender neutral job evaluation and classification is one of the most effective tools for reviewing pay systems, identifying gender biases, and ensuring compliance with the principle of equal pay. The toolkit is a voluntary and practical resource that provides guidance, recommendations, and examples to employers, and using it can support compliance with the directive. But use of the toolkit alone doesn't certify or guarantee compliance. That very much so depends on the context and accuracy of how the methods are applied. It's also not legally binding and doesn't constitute an interpretation of EU or national law. Having said that, it is an incredibly practical and detailed resource. It runs to over 150 pages long, and it's really designed to hold an employer's hand through the entire process. So even though it's not binding, employers who engage with it will be in a much stronger position to demonstrate that their pay systems are objectively based and free from gender bias. Having gender neutral job evaluation and classification systems in place reduces the risk of equal pay discrimination claims and minimises legal and reputational risks, including costly regulatory fines. These systems enable organisations to demonstrate transparently to workers, trade unions, and authorities that pay decisions are fair and based on objective criteria.
Thanks, Christina. So, how is the toolkit structured?
So the toolkit offers 3 tailored pathways depending on the size, sector, and resources of an organisation, which I think is very helpful because it means no employer can say this doesn't apply to us or we're too small for this. So the first pathway is a simplified graduated factor comparison method designed for microorganizations with less than 10 workers. For very small organizations, the toolkit acknowledges that a team of just 2 people is enough. For example, the owner or manager and another worker, and that formal committee structures aren't necessary. The second pathway is designed for small and medium-sized organizations and sets out a streamlined pair comparisons approach. So it's suitable for SMEs and organizations with fewer, more similar jobs. This method involves comparing each job against every other job in the organization to establish a ranking. Finally, the third pathway is a comprehensive analytical point factor job evaluation method designed to be carried out by a job evaluation committee, typically consisting of 2 to 5 members in medium and large organizations with diverse job roles and structured HR processes. This is the most robust approach and provides the strongest protection against gender bias. The toolkit then contained 10 practical tools organized across the 3 stages. So the preparation stage, the implementation stage, and the monitoring and follow-up stage. In the preparation stage, tool 0 provides guidance on understanding and preventing gender bias in the process. This is a really important starting point because even formally neutral systems can reproduce inequalities if biases aren't addressed from the outset. The toolkit makes the point that indirect discrimination is often unintentional, but it can have long-term effects. And it occurs where gender-biased assumptions become built into the rules, systems, or practices used to determine the value of job roles and pays. So even well-intentioned employers can unknowingly perpetuate inequalities if they don't actively guard against bias from the start. Then tool 1 helps employers to get started with their gender-neutral job evaluation. And this includes assembling a committee, creating a project outline, explaining the process within the organization, and building a shared understanding among workers. The toolkit stresses the importance of clear communication here, making sure workers understand that this is about evaluating the job itself and not the person doing it. That distinction between job evaluation and performance evaluation is critical to getting buy-in and avoiding confusion or anxiety among staff. Tool 2 is about gathering job information through questionnaires, interviews, and job profiles. The toolkit provides some sample questionnaires and interview guides, which are very practical resources, and the questionnaire covers the 4 key factors: skills, responsibility, effort, and working conditions. It's designed to capture the full scope of what a job involves, including aspects that might typically go unrecognized, such as emotional effort, coordination work, and interpersonal skills. Then moving on to the implementation stage, there's a dedicated tool for each pathway. Tool 3 focuses on microorganizations, Tool 4 for SMEs, and Tool 5 having the standard approach for larger organizations. Each one guides the employer through the actual evaluation and classification process and helps employers build a fair pay structure based on the results. One key point here is that the toolkit emphasizes that if a job evaluation reveals that some jobs are underpaid relative to their value, employers must adjust salaries upwards. The toolkit's very clear that equal pay is achieved by removing unjustified differences and addressing undervaluation through increasing pay for undervalued women-dominated jobs to match that of equivalent jobs dominated by men, and not by reducing pay for higher paid jobs.
Thanks, Christina. That's a really, really helpful tool. And as we know, under the Pay Transparency Directive, we will be employers in Ireland rather will be furnished with guidance on constructing gender neutral job categories. So while this is EU-wide guidance at the moment, and Christina, you've set out that it's not binding, notwithstanding that it's very helpful, but it is not bespoke to Ireland. And in addition to seeing the draft legislation and ultimately the legislation which will be implemented, we should also see the version of guidance to assist and guide employers to construct their job categories correctly by reference to the Pay Transparency Directive, which will be bespoke to Ireland. So that is awaited also. Just a couple of things also to note in relation to the EU guidance, and that is the monitoring and follow-up stages are expanded upon at Tool 6. And so that helps with adjusting job titles and descriptions to remove gender-biased language. I'd also just call out Tool 7, which is about tracking progress and planning follow-up actions. So that would include conducting checks of the job evaluations, ensuring that workplace policies align with the results, ensuring there's ongoing monitoring, communicating the results to employees, and so forth. There are also two additional tools which are aimed specifically at supporting trade unions and representatives and employees themselves. So look, it's in the show notes, as we mentioned. It's a fairly lengthy document, but certain sections are relevant to certain employers. Not all of it is relevant to all employers in Ireland, so we would encourage you to take a look at that. We have also mentioned our client update, which is in the show notes, and that goes through sort of the, if you like, the checklist of what employers should be doing now in Ireland in order to prepare for the implementation of pay transparency, which, as Christina has mentioned, is not happening now, is likely to happen perhaps in the early part of 2027, maybe before then, we don't know. Obviously, watch this space and we'll post another update as soon as we know. But Ciara, in the meantime, would you just bring us through a recap of what employers should be doing now to prepare?
Yes, absolutely. Well, as a starting point, we strongly recommend employers begin preparing for the directive's implementation at this point, despite the delay in respect to the legislation. And it's certainly our experience that employers are starting to do that and to try and get ahead of the curve. The first step is to audit current pay practices and identify potential gender pay gaps. Employers should be reviewing their performance management and remuneration policies with fresh eyes. Employers should also begin looking at job families to start planning for the categorization of workers. And the principles and processes outlined in the guidance, the toolkit, which Christina has discussed, are extremely helpful and give employers a very practical starting point for assessing whether their pay structures are based on objective gender neutral criteria. And importantly, having such a system in place reduces legal and reputational risk. So it enables an employer to demonstrate to workers, trade unions, and authorities that pay decisions are fair, objectively based, and free from outdated assumptions or gender bias. From a gender pay gap reporting perspective, employers should be looking at all components of remuneration. So, not just base salary, but also bonuses, overtime, allowances, and other variable pay components to ensure that these are allocated using objective and gender neutral criteria. Employers should also take the opportunity to review their job descriptions and job titles to ensure that they're using gender neutral language and accurately reflecting the skills, responsibilities, effort, and working conditions of each role. This is not just about compliance, it's also good practice that strengthens recruitment, performance management, and organizational clarity in general. It also helps workforce planning more broadly. And then finally, employers should also make sure that they have clear processes for how they will respond to individual requests for pay information once the directive is transposed, because workers will have a right to that information and employers will need to provide the information within 2 months of the request. That means having the data readily available and having a clear internal process for handling requests, including potentially sensitive conversations where gaps are identified. And we expect that further guidance will be issued in due course in terms of the format for this process.
That is great. Thank you very much, Ciara and Christina, for your help in putting this together. And I hope this has been very helpful for listeners. I suppose just to recap maybe on the key takeaways. So number one, the pay transparency directive has not been implemented in Ireland as of 7 June 2026. That, however, does not mean that employers in Ireland should not continue with their ongoing preparations. The draft legislation has not yet been published at the date of this podcast, so early June 2026, nor has the guidance for employers in Ireland in relation to the preparation of job categories and gender neutral job evaluation. So that's the first thing. Secondly, as far as we understand it, based on current information, the pre-employment pay transparency obligations may come into force first. So it probably makes sense for employers in Ireland to focus on that element of it and preparing to adjust their recruitment practices. It is not clear when the remainder of the Pay Transparency Directive will be implemented in Ireland. We have seen media reports and statements from various parts of government which would suggest that it could be early 2027. But but we will update you as soon as we have a further update on that. I suppose the third takeaway is to have a look at the EU toolkit on gender neutral job evaluation pending the publication of an Ireland specific toolkit. It's really practical, it's helpful, and as I say, it is in the show notes. Okay, so that's it for this podcast. We hope you found this helpful. Thank you for listening. As always, this podcast does not constitute legal advice. Please do contact us if you have any questions. Thanks for listening and subscribing.